Let's go now to the next one. That is very interesting. Very famous, very influential, Hans Kelsen. Hans Kelsen, many people say that is from Germany. No, he was born in Prague, Austria. Although he spent a bit of time in Germany, and after a while, especially during the World War, he decided, well, let's go away. He went to the United States, and there he taught many things. Today is like one of the most important authors in positivism, Hans Kelsen. Hans Kelsen. So that is interesting. What he believed about justice, no? As a positivist, he said, well, everything is a matter of norms, of the rule. He's a follower of Kant, all of them, I mean, all of them. But he explicitly says more or less the scheme, no? There are two worlds, is and ought to be. Norms are not in the fixed world, in Rex extensa, in the noumeno, that is chaos, no. It's in ought to be, here in our minds. And there are two kinds of laws, with sanction and without sanction. If you put sanction, that will be the legal law. If you don't put sanction, that will be morality. That is the scheme that he approves, and he said that it's important to define what is the law. He will say that in German, what is Sein and what ought to be Sollen. So two kinds of rules, law and morality. One with the force, the state has the monopoly of the force, and another without the force. That is interesting. So why he wanted to define very well what is the law? For me, it's not a good definition, because it is the same naive Austin here. Can you see? So the law is, what is the law? A commandment backed by a sanction. Well, there are many things that are part of the law and are not backed by sanctions. So he wanted to define very well what is the law, because at that time there were many weird ideas of jurisprudence, of the theory of law. He was a good lawyer, a good one, yeah. At that time, remember, who was talking about the law? Malinowski, the teacher of Jomo Kenyatta, Gluckman. And they say, no, the law is reciprocity. The law is what these people say that is the law in these communities, in this kingdom, in Africa. And the law is now for a micro power, and the law is a superstructure, Max. And he said, this stuff is you can use 4-letter words if you want. It doesn't have anything. What do we do with that? I cannot sue anyone in courts with reciprocity and this kind of ideas, superstructure. No, it doesn't help so much. Let's purify the theory of law. And he wrote a book about the pure theory of law, expelling out all these psychologist ideas and things, a sociology, and it doesn't help. It don't help so much to understand what is the law. The law is the norm. The law is the norm, nothing else. So you cannot say, no, forget about that. Let's read what was approved, and we will create a science, a positive science of what is the law. So he restricts the analysis just to the norms. This is the laws backed by Sein. And he ruled out all things that are very strange, that were introducing so many authors at that time in the theory of law, history, politics, but no. One thing is politics and another is the law. We lawyers should be very technical, not including sociology, not including morality. That is interesting. No? So that's why since that moment, well, seriously, some people also, they say one thing is morality and one thing is the law. And if you want to be a lawyer, don't worry about morality. Yeah, that is interesting. So that is interesting to understand. These people are not immoral, are not bad guys. Just they don't say that there cannot be morality. They say one thing is to study the written law and another what could be your ideas of morality, And for me, it's very clever in this point, they address the speech of Hans Kelsen about precisely what is justice in California. It was pronounced in 1952. You will have not so many opportunities of hearing the great jurists of all time. In this case, we have an audio. I will put just the first minutes of that speech, and I will ask you some questions. The question more or less is, what is the relation for Kelsen between morality and the law? So let's hear.
Experience and upon his thought. Ladies and gentlemen, Professor Kelsen.
Chairman, ladies and gentlemen, when Jesus of Nazareth was brought before Pilate and admitted that he was a king, he said, "It was for this that I was born, and for this that I came to the world, to give testimony for truth." Whereupon Pilate asked, "What is truth?" The Roman procurator did not expect, and Jesus did not give an answer to this question. For to give testimony for truth was not the essence of his divine mission as the Messianic king. He was born to give testimony for justice, the justice to be realized in the kingdom of God. And for this justice, he died on the cross. Thus, behind the question of Pilate, what is truth, arises out of the blood of Christ another, still more important question, the eternal question of mankind: what is justice? There is no other question that has been discussed so passionately, no other question for which so much precious blood, so many bitter tears have been shed, no other question to which so much intensive thinking has been devoted by the most illustrious thinkers from Plato to Kant. And yet, this question is today as unanswered as it ever has been. It seems that it is one of those questions to which the resigned wisdom applies, that man cannot find a definite answer, but can only try to improve the question. Justice is primarily a possible but not a necessary quality of a social order, regulating the mutual relations of man. Only secondarily, it is a virtue of man, since a man is just if his behavior conforms to the norms of a social order supposed to be just. But what does it really mean to say that a social order is just? It means that this order regulates the behavior of man in a way satisfactory to all men. That is to say, that all men find their happiness in it. The longing for justice is man's eternal longing for happiness. It is happiness that man cannot find alone as an isolated individual and hence seeks in society. Justice is social happiness. It is happiness guaranteed by a social order. In this sense, Plato, identifying justice with happiness, maintains that only a just man is happy and an unjust man unhappy. It is obvious that there can be no just order, that is, one affording happiness to everyone, as long as one defines the concept of happiness in its original, narrow sense of individual happiness, meaning by a man's happiness what he himself considers it to be. For it is then inevitable that the happiness of one individual will at some time be directly in conflict with that of another. To give an example, love is one of the most important sources of happiness as well as of unhappiness. Let us suppose that two men are in love with one and the same woman, and each believes, rightly or wrongly, that he cannot be happy without having this woman exclusively for his own wife. However, according to law and perhaps also according to her own feelings, a woman can be only the wife of one of them. Hence, the happiness of the one is inevitably the unhappiness of the other. No social order can solve this problem in a satisfactory, that is to say, in a just way, guaranteeing the happiness of both. Even not the famous judgment of the wise King Solomon. He decided, as you know, he decided to divide into two parts a child, which each of two women claimed as her own. But he was willing to attribute a child to the one who should withdraw her claim in order to avoid the death of the child, because, so the king assumed, she truly loved the child. If the Solomonic judgment is just at all, it is so only under the condition that one woman only loves the child. If both love the child, which is quite possible and even probable, since both wish to have it and both withdraw their claim, the dispute remains undecided.
Okay, so in short, he first put the question of justice, the importance to answer what is justice. Second, he says, justice is order, a social order that leads to happiness, social happiness, he will say. So justice is social happiness. So then he'll say, well, there are many things that are impossible, no? If two men love one woman, one will be happy with her and another sad. So there is no social order, no just order that can solve that problem. And how to solve? He didn't answer. He will go in that speech. Someone should decide now who will have that woman, who will have the child in Solomon's example. So at the end, what is justice is what we decide. So from it is interesting, the shift, no? At the very beginning is a very classical approach to justice, no? To distributed justice and legal justice, at least, no? I mean, from a social point of view, not from the individual. But then there is a shift, no? So what is justice? What we want, no? There is a shift. Kelsen at the very beginning was not that positivist, and at the end was the stream. He will say, what is law at the end of his life? Whatever the sovereign approves as a law. Whatever is the wills of the sovereign. So it could be the will of Hitler or the will of Jesus Christ, could be, or God, or whatever you want. No, that is the law. So that is the extreme positivism. No, to say the Nazi regime was the law and it was a good law, because a good law is not related to morality. It's just related to the will, to the decisions, to the whim of the legislator. So is that right? That is interesting. At the very beginning, it seems to be a very classical approach, and it is. But there is a shift, yeah, that is interesting.
Experience.
Well, so later in his life, he developed many things. This is a very important author, by the way, Kelsen. No? If everything is a matter of the will, and is not connected to the real world, because there is no connection between Sein and Sollen, is an ought. So yeah, so is what I believe, what I decide. No, Joseph Ratz will critique Kelsen, saying, well, according to what you say, it is true that a racist should behave in a racist way. Can you see? Yeah, or a Nazi in according to the Nazi regime. Yeah, so there is nothing reasonable, no? It's just the will. It's just the will. So the more extreme positivism doesn't consider what is the role of reason, of the intellect. Doesn't consider neither what is the role of nature. It's just a matter of the will. Yeah. So that is interesting. Now he will divide, and he will be famous for that, of validity and efficacy. One thing is that rules are valid, and another that are fulfilled by the people. So when a norm is valid, norm in order to be valid, it means binding must be authorized by another norm, which in turn is authorized by a higher norm in the system, the grand norm, the constitution. Instead, when we are talking about efficacy, what is happening in reality, what is the connection between these two words, he will say something, yeah, there should be a general adherence to the constitution. And yeah, sometimes people will not obey the constitution, that is clear. you can see in many places. No? The Constitution says incredible things that everyone has rights and everything, and you see it in reality, it's not that happening. No? And this is Germany and Austria. In Kenya, even more, I will say. No? And in my country, the same. We are exactly the same in these kind of things, like in Kenya, in Ecuador. So, if the Constitution is so different to the things that are happening in the country, at one point, there will be a revolution. The revolution will put a new constitution. And the new constitution will be the grand norm, the principal norm for everyone. If still nobody obeys that, there will be another revolution. So that is interesting. That is the way in which he match both things. Okay? Validity and efficacy, Sollen and Sein. The world that exists is and could exist, ought to be. Okay. When many people think in Kelsen, they will think in this, in the pyramid. The legal pyramid, that is a kind of metaphor or explanation of how is the legal system. This is probably one of the most famous things of the pure theory of law, not of Kelsen. Why? Because who developed that was not properly Hans Kelsen, but a disciple called Julius Adolf Merkel. You have the disciple there. And what is interesting to note is that he discovered, well, the rules of validity and efficacy and these kind of things applies perfectly in an order. It's like a pyramid. And Kelsen, in one of the versions of his book, he will say, well, my most important disciple is Julius Merkel. And I can consider him a co-founder of the pure theory of law. Yeah, but people today don't remember Merkel. We remember just Hans Kelsen and the theory of the pyramid that is in his book, for sure. So that is interesting. The theory of the pyramid has two moments, two stages. The first one is a bit more static. The second part will be a more dynamic view of the legal system. So it's interesting, no? Why the agreements, for example, or the legal activity of the citizens are valid? It's clear for Kelsen, we already said, because there is a higher norm, probably a statute could be, that says what you can do, what you cannot. And if you act according to the statute, that will be valid. Now, the next question is, why the statute is valid? Because there is an act, there is a treaty, something like that, that says these matters should be regulated in this way. You can do this or not that. No. So the statute could be valid if the higher norms allows the thing that were regulated. And why? Next question: why the treaties, acts, and other norms are valid? No. Because there is a basic norm, that the grand norm that says you can do this, you cannot do that, this should be ruled in this way, the standard here is in that other way. So, you know, that is why it's valid, not efficacious. No? The efficacy is another question, different. It's politics, but it's not law. And that is interesting. No? The last question is why the Constitution is valid. No? So he didn't answer the same way. That is a tough question, no? Because that was an issue for Kelsen. That was an incredible issue. Why? Because he realized that the answer will be something that is not a norm. For example, history, for example, natural law, for example, revolutions, for example, yeah, and that was a mess for his theory. What was the main purpose of his theory? Expel out sociology, history, superstructures, micropowers, and all these stupid things are not the law. And at the end, his theory, the pure theory of law, should be based in something that is not a norm. Can you see? So that was a mess. That was a mess. And at the very beginning, he answered, no, that is the only thing that natural law and the pure theory of law have similar. No? That at the end is something related to histories. And immediately he rejected that. And he said, no, it's because facts. But he didn't answer very well. More or less, in the last part of Kelsen, he discovered international law. And he said, well, international law will be the base. Why the basic norm is enforced, is valid? Because it is approved by the international community, and that is a kind of agreement, and agreement is a kind of norm, something like that. But as you can see, the answer is not well performed, no? Because it's just to put the question a bit more further. Why international law is valid? So the question remains, it's open, it's not answered. And that is the great failure of the pure theory of law, that he said, just norms, and norms explain everything. And at the end, well, it doesn't explain so much. You need something else. That is the big issue with them. On the other hand, he developed also later in his life nomodynamics. Nomo means law, dynamics, movement, no? The movement of the law. And I will say it's more or less like one author that we saw last week, Niklas Luhmann, no? So at one point, the whole system acquires a kind of autonomy and shows you how to produce norms. That was in Kelsen. That was in Kelsen, and he said, no, the basic norms contains the process, the procedural norms to approve new norms. Yeah. In the judicial process, there is a process to approve what will be the standard in this case, and in many other cases, probably. In the Constitution, there is also some rules that shows you how to approve a law. So first debate, second debate, the president should approve, or some people have veto. Yeah. So there is a process. So the basic norm contains the process, and if you follow the process, you will produce new norms, and this legal system will shape itself. Yeah, nomodynamics is similar to the autopoietic notion of the legal system of Niklas Luhmann. That is interesting, no? Okay, so the question, the basic norm, the original constitution is to be obeyed. Why? We don't know why. According to the theory, pure theory of law of Kelsen. We already answered this question with the example of Milgram's experiment, no? But this is the limit of positivism, I will say. Why you obey the law? Because the law is to be obeyed. Just forget about it. It's to be obeyed. So, and these theories were very successful, very successful, but they were in the middle of the previous century, the 20th century. But there was something here that will change everything. Do you know where is this photo? Which place is this one? Which city? No one? Germany? Yes. Which part of Germany? Well, German, more than, yeah, Nuremberg, yeah, Nuremberg, yeah. Yeah, Nuremberg. Perfect. When this photo was took, when, which moment? At the beginning of the demonstrations. No, it's very famous here in Kenya, the demonstrations of Hitler, no? More than demonstrations to show the world how powerful is the Nazi army. So that was before all the invasion, no? Just so that was incredible. That was in Nuremberg. In Nuremberg, he created a kind of show, the first time ever that a nation will put will record everything in film, in television, to show everywhere in the world how powerful the Nazi regime is. And that was a video about 40 minutes, 1 hour almost, and that never happened in the past. And he invited many journalists all over the world, Hitler, to record what is happening here. And that was a show. That was a show to inflict fear. So in this way, he knew that people will immediately say surrender. No, some nations will surrender when they see that the Nazi regime is there. No, and that's why in the same place that was the beginning of the Nazi attacks. No, after that they will invade Poland and then many other things. Yeah, but like was to inflict fear. So that's why after the Second World War, when everything was lost, the United Nations decided to use the same place that Hitler used to begin all the war to the trials, the trial of Nuremberg. That's why it were the same place. We have some, you have some classmates that I think that are in Nuremberg now because in the mood competition precisely there. And there were many cases here that is interesting. No? I think that were processed for 24 of the most important leaders of the Nazi regime. And some cases were ridiculous, no? Yeah. For example, well, even there was a case of, for example, a wife that heard so many things of the husband in bed, in the bed, she heard about something against Hitler, and she denounced husband, and he was in prison and killed. So that's it there, and many other things. Now here were just the 24 most important leaders of the Nazi regime. I will not put everything here, and they will answer, well, I just was obeying the law. The law was approved by the parliament. I just was obeying the law. You cannot punish me because I obeyed the law. So that was like something that triggers the debate between positivists and natural lawyers. No, positivists will say that was the law; they have no liability. Yeah, and natural lawyer will say, well, the law is not something irrational. Even if someone is asking you for killing your mother, you will kill your mother or not. Yeah, it's the law, so you don't have liability. No, you have, because the law always should be reasonable. Don't you know which one was the most important phrase repeated by the courts in Nuremberg? The most important phrase, because they realized that there is a debate here. Natural lawyers, positivists, is about if we are able to decide this case or not. Yeah. Anyone? Or I will put in the phrase. No, it's a phrase of precisely a follower. He was before that a positivist, but he got a conversion, and from that moment on, he was a natural lawyer, and he said that no law can be unbearably unjust. For sure, there are some cases that we don't know, and probably you can follow what a guy with a white coat says that you should do. Some cases are so evident, yeah, you cannot torture, for example. That is so evident that is bad, no? So evident. And if you do that, you should have liability, no? Criminal liability. Because no law can be unbearably unjust. The Nuremberg trials will repeat this phrase many times. Yeah, there are things that you can do. And today, it's not the same phrase, but it's the same idea. Is in many treaties related to human rights. Many, not just one, many. That says exactly the same. That you cannot commit crimes against humanity, even if any authority, could be the president of your country, ask you for doing that. No, that is not a justification. Never. The president nor the judiciary nor the parliament can ask you for torture, for example, torture, or to rape, or to commit many other things. No, yeah. So no law can be unbearably unjust, and now that is the standard in human rights, and it's clear. It's in many constitutions also. No, you in very serious things, you cannot say someone asked me for that. Okay,